So thanks, Olympia. Thanks, Emily, for including me in the program. I have two faces. I was inside the International Criminal Court around 12 years ago, and now I'm on the academic side. I'm particularly happy that you included the question of preliminary examinations in the context of this program, because I think preliminary examinations are one of the most fundamental innovations that we see how international criminal justice works. I'm of course honored to speak after Rod, who knows much more about case selection than I do, and before Emmerich, who knows much more about preliminary examinations than I do. But maybe I can put some issues into perspective, and particularly the idea courts are typically sort of to be effective if they have robust enforcement powers. Late Antonio Cassese framed this famous idea, right, that international criminal courts are to some extent giants without legs. And it kind of seems to tell us the idea that you need robust powers, you need strong cooperation by states in order to be effective. I think the concept of preliminary examinations is to some extent an antidote to this, because it somehow illustrates the virtues of soft power. In the context of preliminary examinations, Part 9 of the ICC statute, which deals with cooperation, does not apply. If we look at the current configuration of preliminary examinations, we see that maybe to the outside world, some of the most important situations are actually those which are under preliminary examinations. We have three situations, Afghanistan, UK, Iraq, and Ukraine, which involve permanent members of the Security Council. And preliminary examinations have, to some extent, I think, become an instrument to counter the critique that the ICC is only targeting Africa. If we look more closely at preliminary examinations, we see different models. There's one model which I would call the so-called gateway model. According to this is a narrow conception of preliminary examinations, according to which preliminary examinations are mainly then a gateway to investigations. That means they're basically a filter to decide whether or not an investigation should be opened. Under this model, for instance, preliminary examinations, right, don't take much time. Take, for instance, the situation in Libya, where it took the ICC only a couple of days to carry out the preliminary examinations. So in situations where this does not require complex analysis, this gateway model of preliminary examinations is pertinent. But there's a second model which provides greater virtue to preliminary examinations as such. And I call this the kind of purpose-based model towards preliminary examinations, which kind of takes a different starting point, which says that there's some virtue in opening a preliminary examination per se, even if we don't know whether this leads to an investigation or not. In the OTP policy paper on preliminary examination, which has been prepared, we've seen basically two rationales, two purposes that are related to preliminary examination. One is the principle of complementarity, so to foster domestic justice. The other one is the concept of deterrence or prevention. So on this function of preliminary examination is to some extent more closer to the human rights tradition. It would kind of say that there's some virtue in the alert function of international criminal justice, and in the fact that the ICC may have leverage, over states during the preliminary examination that may be even stronger than in the context of investigations, because some of the choices are not yet firmly locked in. The second approach, I think, gains particular significance in situations which require complex situational analysis. This week we had the final announcement about the peace deal in Colombia, and I think Colombia is precisely one of the examples where this second model of preliminary examinations, this purpose-based model, actually unfolded some of its effects. So the second model is of course not without critique. One critique is, should the OTP open a preliminary examination for the purpose of positive complementarity or for the purpose of prevention. Some fear that such a strategy is actually at odds with the constraints and resource limitations of the ICC. And any success of the court is very difficult to measure. How do you translate this in concrete successes? Because you cannot quantify it in terms of number of cases. Other states have criticized preliminary examination for their overreach. They have claimed that preliminary examinations have to some extent become a little bit too close to kind of naming and shaming paradigms that we see in the human rights context. So they fear that the OTP will turn too much into a human rights body by fostering this purpose-based approach. Again, other actors, civil society organizations, have criticized the OTP for its underreach, namely that it did not make most of its preliminary examinations. So they said the OTP should even be more active in relation to preliminary examinations in order to guide choices on peace and justice. So preliminary examination should not only be centered towards the ICC as such, but it should have a broader function in relation to advice, monitoring, and dialogue with domestic jurisdictions. So in my view, having seen the ICC perform over a number of years, in my view, we need both models. We need the gateway model and we need the purpose-based model. Both models are needed in light of the diversity of situations that the ICC faces. But the purpose-based model requires certain caveats, of course. One relates to methodology. First of all, it requires the development of a certain hypothesis of potential cases in the situations early on. Otherwise, preliminary examinations might indeed become very broad. Secondly, a purpose-based approach might only work in specific contexts. It may strengthen domestic investigation or prosecution in countries with a strong rule of law culture, but it's likely to be less effective in fragile environments. And certainly there's a certain timing dilemma. If a preliminary examination, as we've seen it in the context of some situations, is open too long, without corresponding ICC action, the ICC actually loses some of its leverage. It easily comes to be seen as powerless or ineffective. So this runs against the interest of a purpose-based approach. This brings me to the second element, the legal framework of preliminary examinations. If we look at the statute, we see that this framework is thoroughly underdeveloped. The statute provides a lot of attention to how the ICC should exercise jurisdiction, how to get things started, but then how to get out of a situation, we have much less information. The drafters didn't really contemplate that question. So the in, and what already mentioned it, also in relation to selection of situations, is guided in terms of admissibility criteria, gravity, interest of justice. All of these are legal criteria and some of them are subject to judicial scrutiny. Others are matter of prosecutorial discretion. The decision not to take action is already less regulated. A decision not to initiate a preliminary examination is, of course, of key importance to information providers and potential victims. Some elements are specified in Article 53, but there are competing readings what decisions are subject to review. The out, that is the decision how to close a situation, is even less specified. We have really no criteria. And it is unclear what should serve as a benchmark. What already elaborated on admissibility and complementarity. Should some of the same benchmarks that the ICC applies in relation to its existing cases apply also to a closure strategy? Should the ICC only exit a situation once there is an effective strategy domestically to investigate and prosecute these crimes? Does there need to be evidence of concrete domestic investigative steps? And what type of evidence should the OTP then share with domestic jurisdictions? So there's a certain discrepancy, I would argue. The statute provides criteria to what the court should do, but it provides less guidance on what it does not do. And I would argue that the in requires as much attention as the vision of the out. What are the main criteria that guide selection and prioritization? As I said, I think if we look at the statute, we see that the positive criteria are specified and provide some guidance. The selection of preliminary examinations is guided normally is divided into 4 phases. Phase 1 is an initial assessment of all of the information on alleged crimes received under Article 15. Phase 2 relates then to the classical jurisdictional analysis. Phase 3 involves analysis of admissibility, complementarity, and gravity, and Phase 4 looks at the interest of justice. So all of these are legal criteria which guide selection. Obviously, selection is not an exact science. It requires a certain degree of flexibility. And the existing ICC situations differ in scope, and they are dynamic. In some situations, there's continuing or recurring violence. So let me raise two issues in relation to preliminary examination that merit consideration. The first of all is whether there should be a phased approach towards preliminary examination versus parallel consideration. The idea that preliminary examinations are divided into different phases seems to suggest there's a kind of sequenced approach of how they should be implemented. So, and this approach has raised some concerns that analysis may kind of get stuck at for instance, the jurisdictional analysis without then proceeding to analysis of other criteria. And obviously, we've seen that some of the situations have been under consideration for a number of years. So there are certain proposals that a more holistic methodology, which wouldn't look at these phases as a kind of sequenced model, but more as a more holistic approach towards this criteria, might make more sense. Second, the issue of gravity has been raised already. Gravity is one of the main criteria guiding selection, and it has caused, obviously, considerable confusion in the case law of the ICC. We have seen some early case law by chambers which said that gravity is tied to systematic or large-scale conduct and social alarm, but this test has then been overruled by the appeals chamber. Today, we have a gravity approach which recognizes that there are certain quantitative and there are certain qualitative factors which guide gravity. And there are four criteria which the LTP uses, which are the scale of the crimes, which are the nature of the crimes, their manner of commission, and their impact. I would argue that this more flexible approach, basing on these four types of criteria, is actually an asset, because it allows wider investigation and prosecution of a broad spectrum of criminality and diversity of situations. So it allows the prosecution, the LTP, to focus on situations of crisis that are illustrative of certain types of criminality. It also allows the LTP to basically look into the conduct of big powers. But gravity poses certain dilemmas. And the first one is basically the typology of a comparative gravity analysis. So the very idea that when you would kind of choose what type of situations the ICC would look into, that you would kind of start to compare situations in terms of their level of gravity. Such a lens was applied in the early practice, but I think it's become clear that it's to some extent like comparing apples and oranges. I mean, the Kenyan situation involved thousands of victims. The Ivory Coast situation involved, hundreds of civilians. The Comoros situation involved only one specific incident. So you need really, a genuine and case-specific analysis to treat each situation on its own, rather than to deploy a comparative logic. Second, there's a certain tension between gravity as an argument of situational analysis and its connection to hypothetical cases. So gravity shifts over time. In the context of an opening of a preliminary examination, there's often a very broad vision of gravity, but which is then tied down to more specific factors in the context of the course of the preliminary examinations. We've seen patterns like electoral violence, attacks on cultural property, attacks on peacekeepers, use of child soldiers being effectively prosecuted as a result of a situation rather than the situation in its entirety. And so this creates certain frictions between expectation and outcome. In the Mavi Mamara decision, basically the pretrial chamber questions the prosecutor analysis in relation to gravity and invited the prosecutor to consider investigations, this is, in my view, an undesirable precedent because it kind of prescribes a specific vision of gravity on the OTP, which again the judges might have difficulty to assess. So I generally think that there is some virtue in preserving a certain degree of prosecutorial discretion also in the context of this analysis. But there's a deeper question in my view, whether opening many situations and addressing them through a few cases is more effective than doing fewer cases, fewer situations, but doing them deeply. Before moving to the conclusions, a few words about prior authorization. Prior authorization is less juridified, so less framed in legal terms than the issue of selection. So, and one issue which has been neglected in the context of the framework of the ICC is particularly the time factor. So, what situations should be treated first? How long should they remain open? One contested question is the question to what extent there should be a time limit for preliminary examinations. And the debate seems to turn in certain wheels. The OTPs always pleads there should not be any hard time limits. And there are good reasons. It seems unfeasible to press the OTP to go ahead with investigations in a situation, right, where it believes that there's simply not sufficient evidence, or to close the preliminary examination if the underlying situation is dynamic. But I think it would be useful to develop certain benchmarks and channels of communications where situations are pending for several years. Second, I think in situations which require more complex analysis, it might be beneficial to strengthen the monitoring structures of the OTP, and particularly if also personnel switches from one situation to the other, certain knowledge might get lost and certain situations might probably get less attention, structural attention, than they deserve over time. So let me conclude. In my view, I think the ICC has made much progress in increasing the transparency of preliminary examinations. Many concepts and methodologies really needed to be developed from scratch. I would argue that a preliminary examination may have certain important effects without the ICC actually reaching the stage of the case from a systemic perspective. But I would argue that some further considerations really require work. First of all, whether and under what conditions a preliminary examination may have positive effects on complementarity. Second, how the link between preliminary examination and other fact finders and human rights bodies could be improved. And third, how the long-term implication of ICC engagement can be refined. So I would argue we are neither at the beginning of the end nor at the end of the beginning. Thank you.